Welcome to Sri Lankan Law Teacher YouTube channel. Uh, Today I am going to teach you about legal strategies for recoveries. Recoveries means for financial institutions, when they lend money, we need to recover those monies by the financial institutions. Uh, when they lend money. So today in this lesson, I am going to teach you the legal strategies available for the financial institutions for the recovery. Okay. First of all, you can subscribe my channel, YouTube channel, and share this, like this, in order to receive more productive videos in the future. Okay. Uh, as the first step, there are two stages of decision making. That means for financial institutions at the branch level, they can take some decisions like bank documents, securities, proper documentation, ledger account statements, actual transactions, correspondences. All these things will help in legal recoveries. At the ground level, mortgage property, state of property situation and possession, this type of things, present realizable value, all these things will help in recovering the lent money for a financial institution. These are the preliminary requirements. This is the kind of a classification of the NPLs, that means non-performing loans. Special mention category: after lending money as a loan facility, if the loan facility is not performing within 3 months, it is called special mention. Within 6 months, if it is older than 6 months, it is called substandard. 3 to 6 months, within 3 to 6 months it is called substandard. Then that non-performing loan category is within 12 months, 6 to 12 months, it is called doubtful category. Then if it is beyond 18 months, it is what we call loss category. Okay, that means beyond 3 months special mention, beyond 6 months it is substandard, beyond 12 months doubtful, and beyond 18 months it is classified as loss facility. Okay, then we have several options, strategies in recovering these non-performing loans, non-performing facilities. First of all, we can uh, send the material to mediation board. Mediation board is a very good strategy, because it is like it's kind of a win-win situation for the financial institution as well as for the borrower. It is a win-win situation because there is no losers at the mediation board. It's kind of a negotiation thing, so no no need to get the assistance of the lawyers and that kind of no expenses. So it's kind of a negotiation process in this mediation board thing. Thereafter we have the second option. If the mediation board option is failed, if in other words, if we can't find a solution at the mediation board, we can go for court action, file an action in court. Then we also have that financial institutions have this thing called parate execution, say, without going to courts, by just passing a board resolution at the directors of board meeting. They can uh, uh, sell this property in a public auction, and recover the monies due. Then do seizure, parate execution and sale. That kind of things, especially seizures happens in leasing facilities. Okay, let's move. This is mediation board. Mediation board functions happening. Mediation board, there's an act called Mediation Board Act number 72 of 1988. Section 7 says uh, any the commercial transaction, if the value is less than 25,000 or less, they can go for we can go for mediation board action. uh, it has been once again amended. The Mediation Board Amendment Act number 4 of 2011, section 2 says any commercial transaction value less than 250,000 no less than 250,000, then we can go for mediation board action. Then second one is the filing legal action, that means court actions. Documents to be forwarded to the legal officer. These are the documents that should be forwarded to a legal officer in order to effect the legal action for a financial institution. Duly completed Annexure 3. It contains amount on which further interest is due, date from further interest is due, rate at which further interest is due, photocopies of all the security documents, loan applications, agreements, guarantees, indemnity bonds, mortgage bonds, etc. This is the initiating legal action. Dispatch letters of demand. Normally we send letter of demands in a legal action to the borrowers, guarantors, or whatever indemnities. Defaulters response to letter of demands persuaded him to settle uh, by repaying all of unpaid facility and all dues to the bank, or by paying in installments, by repaying adequate part of monies due to the bank, and giving schemes for repayment of the total dues. Then duly certified the statement of account, signature of manager, designation, date, branch, rubber stamp. Copies of LDs dispatched to borrower, letter of demands, guarantees or indemnities. Copy of non-settlement certificate of the mediation board. That means in a mediation board, if the mediation board cannot settle the dispute, what they do is they issue non-settlement certificate. If you want to go for a legal action in the courts, we need this thing, non-settlement certificate. Okay. Then we have in case of a company, partnership, sale, proprietorship, we need the certificate of business names registration, certificate of incorporation. We call it BR. Board resolution also needed. Then debt recovery is special provision, and this is one of the very important acts in this country. Number 2 of 1990 as amended by Act number 9 of 1990. Section 2 says not less than 150,000 rupees we can go for legal action under this act. Then section 4, documents should be produced properly stamped, should not be suspicious, should not be patient by prescription. Okay. Then prescription of actions. Prescription of actions means this is the minimum time period within which we have to file a legal action. Otherwise, beyond this time period, we can't file a action due to prescription. Loans, if it's a loan, within 6 years we have to file the litigation action. Mortgages 10 years, permanent overdraft 6 years, and temporary overdraft this 3 years. Okay, then parate execution. This is a procedure recovery of loans by banks, Special Provision Act number 4 1990. This is extended the right of parate execution to all commercial banks. Previously, it was only restricted to state banks, but this has been expanded to other the commercial banks, even private banks. Recovery of loans by banks, Special Provisions Amendment Act number 1 of 2011. This is the Amendment Act. Amount of loans should not be less than rupees 5 million. If it is below 5 million, we can't do the parate execution. The accrued interest and any penalty shall not be taken into consideration. Okay. Then we can go for recover. Okay, recovery of loans by banks, Special Provision Amendment Act number 19 of 2011. The word amount has replaced with the principal amount borrowed. Okay, that means amount should be principal amount, not the interest or late fees or whatever. Those can't be used. So this is the end of this presentation. Thank you very much. Please don't hesitate to subscribe my channel. I need your support to get this popularized. So please make sure that in order to receive this type of valuable presentations in the future, you may subscribe my channel, as well as you can share this, like this. No, thank you very much.